99 times out of 100, a company or an executive reach out to me, they attach an agreement and they say, hey Alex, can you review this and let me know if it's enforceable? And the answer is almost always the same. Looks good on paper, but that's not actually what I care about. Before you enforce a non-compete or stay locked out of your industry because you signed one, there's something you need to know about whether it actually holds up. Hey there, my name is Alex Castro. I'm a labor and employment attorney with AXC Legal based out of Fort Lauderdale, Florida. Everything that we're going to talk about today, it's not legal advice. It's general information about the landscape of non-competes generally and what you need to know about them in order to see whether the one you have in front of you is enforceable or not. 99 times out of 100, a company or an executive reach out to me, they attach an agreement and they say, hey Alex, can you review this and let me know if it's enforceable? And the answer is almost always the same. Looks good on paper, but that's not actually what I care about. And that's not even really what the law cares about in terms of enforceability. What matters far more is this actual relationship between an employer and an employee, what the company's trying to protect, what the employee knows and has been exposed to. That's where enforceability about non-competes always falls into question. Let's start with the basics. Non-competes are creatures of statute. That means there is a law out there that says what they need to have in order to be enforceable. And what they pretty much all say is that an employer needs to have a legitimate business interest that is protectable in order to have a non-compete enforced against somebody. The law recognizes that that's a big deal, and it is not a big fan of it. Take Florida, for example, which might very well be the most friendly non-compete state in the country. Even in Florida, non-competes are still disfavored in the black letter of the law. An employer who wants to enforce these needs to jump through some pretty high hoops. And as of a new law passed in 2025, Florida law now says that if an employer meets a handful of requirements, there's now a presumption of validity and enforceability of a non-compete agreement. What does that look like? It applies to folks who meet certain wage standards. If the employer gives them at least 7 days to review and sign it, the non-compete also has to have a clause in there that specifically says the employee is going to receive and acknowledges that they will be receiving confidential information of the employers during their employment. And finally, at the end of the employee's employment, if they're put on a notice period where they're not actually working, the non-compete period needs to be reduced day by day for every non-working day. Basically, the clock starts ticking. Well, first, let's start with what kind of access and exposure the employee legitimately had. Let's take a really extreme example to illustrate that. Let's say you've given the exact same non-compete agreement to a janitor versus the CFO. What is the real likelihood that the janitor had access to sensitive pricing strategies, negotiations that the company was on, its client and customer list? It's probably pretty low, right? But compare and contrast that to the access and exposure that the CFO had in that scenario, and you can imagine how much more likely it is for the CFO to have been in possession or had access to that information. We're not really as concerned about the janitor going to go do maintenance and cleanup for another company, even though it's in the same industry and even though it technically falls under the definition of a competitive business under the non-compete agreement. At the end of the day, that's what matters. Is the investment that the company has made into the employee, what they now have knowledge, access, and exposure to, is the company who gave the non-compete now at risk by that employee now moving on to somebody else. Above all else, there needs to be a protectable, legitimate business interest on the part of the company. Something that justifies saying, employee, we gave you access to all of this information to do your job for us and to have gainful employment. But we can't have you going off and taking that to a competitor because otherwise we're just harming ourselves by having given you that. And it's so important that companies and executives have a grip on what exactly this non-compete is trying to do and what it's trying to enforce, because out of all the litigation, at least that I practice in, non-compete litigation might just be some of the most expensive stuff. Why? Because it's urgent. An employee who moves off to a competitor is at risk of pretty much immediately divulging secrets. What that means is these cases often need to be figured out and completely resolved within 2 months. Litigation that can often take a year or two will be condensed down to 2 months, 3 months, and all the costs that come with it are going to happen right then and there. So your budget is going to be blown out of the water super fast if you find yourself in non-compete litigation. I'm talking about at a minimum $50,000 within maybe like 1 or 2 months, and that's only the beginning. So think carefully about whether or not you want to get into these disputes, and make sure you have your reasonings backed up ahead of time, because otherwise you're going to be scrambling and you're going to be paying out of pocket a ton of money only to find out that you had it wrong in the first place. And if anything we've talked about today sounds familiar or sounds like something that you've been struggling with, click the link below to schedule a consultation with me.